Thank you, Mr. Chairman. Ms. Bryan, I can remember when I learned that Tyler had died and was so moved by everything that had gone before that to try to create a situation where that circumstance didn't arise. A couple of things. First, there have been other patients in this short period of time since these moves have begun who've also not, I would say, not survived the moves. Is that true?
Yes, sir. We had a 93-year-old woman who lived next door to Taylor and Tyler at the training center, and she was also forced to move at age 93, and she died within weeks. I think Tyler was the 10th death of training center out when they were trying to close that building.
Just from the Lynchburg Training Center? From
the Lynchburg Training Center. Tyler was the 10th death.
And how many were in the building before they closed it?
42 when we got the letters.
10 out of 42.
I'm not sure if they were all central. But when we have to think that Hiram Davis received people from South Side as well, and possibly from Northern.
Can you explain the difference in the care between the two facilities where your son resided?
Oh, it's night and day difference. Central Virginia Training Center is, well, it was a skilled nursing facility. It was ADA compliant. It had been renovated in 2011. They lived in a first-floor fire egress 5-star facility with only one deficiency in 2016. Beautiful room, bathroom, physical therapy, beautiful paint, open windows, light.
Did you consider that you and your sons were part of a community there?
Oh, definitely. In fact, he was 20 minutes away from me at work, 35 minutes away from us at home. We visited regularly. My mother visited often. My grandchildren went to see the boys there. I mean, it's like being on a college campus. You're not locked down. It's very different. And
the change was very sudden. It came far sooner than you'd originally been advised.
Yes, I rode in the ambulance with Taylor. The physician rode in the ambulance with Tyler. They were so worried about Tyler dying en route that I was asked to rent a helicopter for $10,000 so Tyler could fly to Hiram Davis because they were concerned about Tyler dying just to go down the road.
Thank you. Ms. Larman, why do P&As push for the elimination of ICFs if it's known that some individuals with profound intellectual and developmental disabilities need institutional care to live?
I've received that question so much by families that I'm trying to make aware of their rights. I'm just a volunteer parent here, and I'm serving as somebody who's going around and explaining to them what's happening with these P&As. I don't know. I think it's ideological. I think that there are people that truly believe that everybody can live in the community regardless of their needs. I've heard those type of statements. I would like to say that P&As do force closings by these actions. Even before these actions are brought, states are so afraid. They don't want to get bogged down in this litigation. In Ohio, 2 centers closed before the litigation was even brought to try to keep this litigation from happening. And DRO still went ahead and brought the lawsuit. DRO was the P&A of the individuals whose centers closed, but DRO did not reach out to the people who were coming to the state legislature and saying, we don't want our center to close. They did not represent those individuals to retain their Medicaid accommodation. So no, DRO was more than happy to have those centers close. And in this case, what they're looking for is a single-stroke solution to move people out.
So why are motions to intervene an important tool for families facing a class action lawsuit that they don't want to participate in?
If you, in my testimony, my larger testimony, the judge in our case, Judge Edmund Sargis, ruled that without our intervention, our rights would not have been protected in this lawsuit. And in the Ligas case in Illinois, the judge basically said the same thing. Without the intervention of their families, their rights would have been overlooked entirely.
Mr. Kinsler, per your statement, the Department of Justice offered a cost argument in the settlement negotiations with the state of Virginia, did they not? Claiming that the state could serve nearly 3 people in the community for each person in a training center. Let me ask my question. Then, do statements like this essentially ignore the extensive care and services that persons with substantial disability like your son need?
Yeah, they tend to be apples to oranges comparison, as assumed in your question. First of all, if you look at the community, the people with this level of disability are 5% or less of the disability community. In the facilities, they are, I'll give you an example of the demographics at Northern Virginia Training Center when it existed. The 87% of the people had a diagnosis of severe or profound intellectual disability. In addition to that, 155 had 2 or more conditions ranging from epilepsy, cerebral palsy, behavior disorders. 139 couldn't dress themselves, 139 couldn't feed themselves or go to the toilet by themselves. So you're dealing, one, with a different population, but also with a different constellation of services.
Thank you. Mr. Chairman, my time's expired. I wonder if I might ask a question or two of Ms. Barkoff.
Chairman's recognized for so much time as he may consume.
Thank you, Mr. Chairman. The gentleman, I hope, will also be given that accommodation if he so desires. Ms. Barkoff, in your written testimony, you state that, quote, "We have seen abuse and neglect in both institutions and community settings." Are you aware of any P&As bringing class actions to halt these systemic problems at group homes or other community-based settings?
So I am aware of a lot of advocacy that happens. You know, P&As spend maybe about 5% of their resources and time doing class actions. You know, most of their
But any with regard to
abuse in group homes? I don't know of any class actions. I know of a lot of advocacy that happens there in terms of what tools we have to bring litigation. That the ADA certainly is not something that we could use to address that. The Constitution that we've used in challenging state confinement, so again, as I described in my testimony, those don't apply in group homes. People with disabilities and the P&As would welcome the opportunity to have legal tools to address
Class action
those.
lawsuits can be brought against public or private institutions, can they not?
Class action lawsuits
Correct.
can be brought against public entities for funding. So when there have been class
but
actions.
You're not answering my questions. I
sorry.
want you to answer the question about
Sure.
whether or not private facilities can have class actions brought against them by a P&A.
Yes, so for
Okay,
example,
let me follow up.
yes.
I have a follow-up
yes.
question.
Yes,
And that's
this,
this.
for example, the group homes in New York State, so that's an example of thousands of people with psychiatric disabilities who were in large private, who were in group homes called adult care homes where people's rights were being violated, people were unnecessarily there.
But any in Virginia that you're aware of?
I'm not aware in Virginia.
So,
I know in private nursing homes where people with intellectual disabilities are not getting active treatment. So my organization is involved in a lawsuit in Texas where thousands of people with intellectual and developmental disabilities are inappropriately placed in nursing homes. The care they're getting in nursing homes are inadequate.
But not the small group homes or the community-based programs. So here's my question. Doesn't the lack of such cases, despite numerous reports of such abuse, some of which you've just cited, throughout the years, including a recent HHS report issued earlier this year, suggest that the P&As have an anti-institution agenda rather than an agenda to protect all people with IDD from abuse and to promote choice?
No, I don't think that's the case. Again, the P&As have been working very hard around ensuring protections in the community. This report came out, and already the P&As and other advocates around community services have approached the Centers for Medicare and Medicaid Services, and the Administration for Community Living, and absolutely asked to work with them on additional regulations for the community.
Should families like Mrs. Larmond and Ms. Bryant and Mr. Kindler have the opportunity to have advance notice of a class action lawsuit?
I think that there are already opportunities for notice. I know that the Congress has included in appropriations opportunities for notice, and I do think that
you don't object to that.
I don't know exactly what the proposal would be, but I do think engaging stakeholders and making that public.
What about the right of families to opt out and deal separately, individually with the state in the courts or through private negotiations? Should they have that right?
The reason that Rule 23B2 classes don't allow opt-out is because it creates changes across the board in policies that defendants put in place. It's unworkable to create an opt-out. And in addition, many cases now, as courts look at how to define cohesive classes, don't include people who oppose moving to the community. In the case that Ms. Lehrman referred to, the class definition does not include people who would oppose. So already the existing class action rules create opportunities to narrow classes to people who are cohesive. When people are not included as part of the class, they have opportunities.
You don't object to?
I think the existing rules already and the rules that apply to class actions across the board provide the types of protections that have been interpreted by the courts to make sure people.
Kindler, you want to respond to that?
Yeah, there is no requirement for advance notice, so advance notice is not afforded. As I mentioned, in the DOJ situation, they list people they talk to in the administration, in the community, staffs, administrators, everybody except parents. So DOJ and P&A typically do not provide any notice, and both the special litigation section and P&As have issued things that all read like this community for everyone, for everything. So,
Ms. Larman, are you satisfied with the rules regarding the ability to opt out?
No, I'm not. I mean, I've had to raise $100,000 to try to get into this lawsuit with other families. I mean, that has been an incredibly stressful situation for me for the past 2 years. I will tell you that the lawsuit, I mean, the judge said our rights were not protected until we intervened. The class definition that Ms. Barkoff, and actually her organization is suing the state along with Disability Rights Ohio, it does say for people who, the class does not include people who don't oppose it, but how are you going to know if they oppose the community or not if you don't ask them? And none of these families even know that the class action's taking place. I mean, these are 6,000 people all over the state of Ohio. When DRO announced their lawsuit, they actually did it in a private press event. I found out about it and I went to the event, and the executive director said, you know, Ms. Larman, this is really supposed to be a private press event, but I'll let you stay. I mean, my children are affected by this class action.
Ms. Barkoff, I am very glad that your brother is no longer in an institution where I think, based on what you've told me, it was very inappropriate for him to be there. And I think there are a lot of other people who are in those circumstances as well. But I also believe that the process by which this has been undertaken is very inflexible, doesn't recognize the fact that there are many people, probably a minority of all the people who are in facilities like this, but many, many people represented by 3 people with you today, that it's inflexible. It does not recognize their extraordinary circumstances and the needs of their children. And I think that we have to work together to find more flexibility for them, so they're not swept up and treated the same way as other people who may well deserve to be in a class action. I support legislation separate and apart from this issue that says that people in a class action have to have similar harm, similar circumstances to be included in a class. Otherwise, they should be treated separately, individually, as most of us would want to be if we were sued by somebody. So thank you, Mr. Chairman.
Thank you, Mr. Chairman. The chair will now recognize the ranking member, Mr. Cohen, for a unanimous consent request.
Thank you. I have a series of statements from different groups of concern, including the American Association of People with Disabilities and Autism Society, et cetera, Epilepsy Foundation. I'd like to enter into the record.
Without objection, all of these documents will be introduced into the record, and this...
Thank you.
Thank you, Mr. Cohen, and this concludes today's hearing, and thank you to all of our witnesses for your testimony and your responses to our questions. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This concludes today's hearing. Adjourned.